All right. Well, this is the inaugural podcast for the MKCI Comp podcast. I call it the Compcast. It's going to be every month or so. And this is our first episode. And I am very pleased to have retired Judge Watson Barrick as my inaugural guest.
Thank you.
Barrick, thank you for coming.
It's a pleasure. Yeah, this is a podcast. It's how to approach and think about workers' compensation. It's going to be fairly long. It will be dry, and some of these things will. You'll probably have to put it on pause and have a cup of coffee.
No, or a drink. One of the two. We're going to try to keep it moving. So this is going to just be some general questions that I have, and I thought that people might want to know about how a judge thinks about certain things. So I thought this would be a good platform to do that. So I guess I'm going to start with just some basic questions. When you retired, I believe you were the longest sitting judge of compensation.
Correct.
In the state of New Jersey.
That's correct. Yeah, I was sitting for 21 years.
Okay.
And then before that, I was 5 years municipal judge in Monmouth County and in Middlesex.
Okay. So 21 years, you got in 2000, you just retired in 2021, correct?
Correct.
Mm-hmm.
April Fool's Day.
We will not cast any meaning to that. I know one of the questions I asked, and I wasn't sure if you would remember this, was just estimating how many cases do you think you heard in your career?
I don't know.
I didn't think
you have to break it down as conferences and trials. I didn't keep stats. Daily dockets are 60 to 90 cases a day, depending on where you are. Most of your dockets put off for discovery. If a conference is asked, the following questions are what we always ask. One, is it ready? Do you have all the reports? Has it been conferenced before? The judge will then read the reports. Some judges will do it orally, ask questions about the reports, and then ask counsel, what did I miss? Is there anything that I don't know about this case? Then it'll proceed with a suggestion for a resolution, whether it's a med motion or permanency, and then a discussion will follow as to where the case should move from there. Sometimes reports don't give you the full story about a petitioner's functional condition. So we take testimony to hear from the petitioner what his complaints are, especially if the issue is whether it should be 30% or over 30%, which is called a hump, and then we'll reconference the case to try to see if the parties can meet somewhere in between, and if not, then you just simply schedule the doctors and take the testimony.
Okay, that's interesting. During the time that you were on the bench, I know you handled what I would call a regular garden variety workers' compensation case, but did you have any opportunity to handle second injury fund or the uninsured fund cases?
Yeah, I probably was the most familiar judge with the UEF. We'll get to that, I guess, in a minute. Second, how do you approach and think about second injury fund cases? And what the best way to do this is to understand second injury fund cases and uninsured cases are two totally different beasts. With the second injury fund, the first question is the petitioner total? The second question is, did the petitioner have any prior functional loss? The fund will not pay unless there's objective prior functional loss. Now, how does that translate into what an attorney and a judge is thinking And there's a really simple flow chart. The second injury fund is like a conference, like any other conference for permanency, but with fund participation. Now, if the fund is not total, the fund then leaves the case and it goes back to a regular conference as to how the amount of permanent partial disability. If the last accident is so bad that it took the petitioner out of the workforce in and of itself, then there's no fund participation, and it's called a total last accident case. And it's a scam. So I apologize. So it's a total last accident case. It's the worst case for a respondent because they have to pay forever.
Absolutely. Been there.
And now if total and the last accident did not take the petitioner in and out of the workplace, then you look for pre-existing conditions. It's not articulately said, but you do not look at the past awards and add them up. If you apportion a number, then the respondent number goes first, 40, 60%, the fund paying the rest. To sweeten the pot for the fund to get them involved, setting the data totality is when the fund starts paying. Later is helpful for the fund. The data totality can be when the doctor totals the petitioner, last date attempt, or an arbitrary date. The fund does not pay for progressive diseases. For example, cancer, progressive diseases are not fundable. This section on second injury fund cases could easily go a day. So I'm trying to let you approach this and have some idea.
Yeah.
The key to the defense is to get the fund to pay any percentage. Fighting over 10 to 30% doesn't mathematically make sense. It's a home run and is a waste of time. Do the math, take a look at it.
You want that lifetime payment from the fund. That's what always is at least in my opinion, is what you're looking for when you're trying, as a respondent at least.
That's right, because that removes the respondent from paying millions of dollars.
Right.
You have to do the math. Now, so when you're thinking about this, the questions that you have to put yourself through, not only as a judge, but as a practicing attorney, is, are you really going to go to trial and take a risk of the case being total last accident? There's going to be a theme here throughout this podcast. The theme here is going to be trust the attorney who is in chambers. They're there, they understand the lay of the land, they understand the players, they know dispositions, they know the judge. Now, the other part of this is preparing for a fund conference. And a lot of times we don't see them prepared well. In preparing a conference, do you have the prior reports of the prior cases? Do you have the transcripts of the prior cases? Because you're trying to show objective functional loss. It could also be a monetary loss. Has the person changed jobs? Has he had to go on light duty? Has he had to change jobs and make less money? Has he missed time from work because of this? Those are the questions that you really, and you have to have a thought process when evaluating your risk in the fund case. When you go to the UEF, you're in a completely different world. A UEF conference and seminar would take a couple days to really delve into the law, much of which is unsettled. However, we can talk about how to handle it. I gave a ICL seminar with law and arguments by both the parties and the UEF deputy. Chris probably has a copy. Back then, we were allowed to go and give out cases. There are 4 or 5 cases in that documentation. If you're going to go in and start having a UEF case, that's where you want to start, because that explains the UEF law and what the open issues are. However, I'm going to, just so that you can have a handle on it, just touch very briefly on how it works. Once the fund has been joined because someone is alleged not to have insurance, you ask your attorney to advise whether there are deficiencies in A, cancellation of policy, or B, a non-renewal. Everything has different rules. Now, at this point, you have to think about doing a cost-based analysis to see if a trial costs and risks outweigh paying an appropriate Section 20. If not, then you would suggest that you bifurcate on the issues. Was there notice? Was there proper cancellation? There's going to be some arguments by the UEF that, quite frankly, the court doesn't accept, but we have unsettled law. So what happens is you try your case and you move on. So only the UEF is ripe for issues for Section 20. I need to touch upon Section 20 and how you approach that. It kind of dovetails in. I'm getting a little off your questions, but
that's fine. I think it's a good point to bring up.
As to a Section 20, a judge can't accept that unless there's a true issue. Okay, and that includes reopeners. Just because you're going to reopener doesn't mean that it's automatic Section 20. So if it's compensable, don't bother wasting anybody's time unless you have a real reason for that. Okay.
Good point. And that can include no additional treatment. That can include zero disability,
subsequent
accidents, all those things. That's all things you have to take into consideration on the Section 20s, especially on the reopeners. So I guess another question was, during the time that you were on the bench, did you see overall your caseload increase, decrease, roughly stay the same? What would you think over your tenure? Was it more when you first came on the bench and less when you left, or
the filings fluctuate. Some people feel that it's dependent upon the economy. Economy goes down, filings go up. I have not followed that. Caseload depends upon the vicinage and the number of judges in each vicinage. Are they short judges? Are they full judges? I've been in Hudson. I've been in Union. I've been in Essex. I've been in New Brunswick. I've been in Ocean, and I've been in Freehold. And each one is different. And it's a different world when you kind of go over the Raritan, and kind of a different world when you go south of Ocean. And that's why you have to trust your attorneys. Well, why am I getting a small Section 20 in Newark, but I have to pay more money in Ocean? And again, that's part of the theme. Trust your attorneys. They're in chambers. They know what's happening. They know the judges, they know the players, and they know the numbers for that vicinage.
All true. One of the first questions we usually ask is, where's the case venued? When somebody asks, what kind of numbers are you looking at least for reserves or things like that, that all impacts, those types of things. So here's an interesting question. Your wife is also a workers' compensation judge, Judge Leslie Barrick, and she's still sitting. Actually, she's now the supervising judge in Freehold, correct? And for a short time, you were actually in the same vicinage together. So I guess my question was, did the job ever go home with the two of you, or were you guys pretty good at keeping things in the office?
And how is it with your wife?
I was gonna say I have the exact same issue, so that's why I felt like I could ask this question.
Yeah, sure. We were attorneys. We had a firm together. We trial teamed things. So we worked together. Sometimes, of course, you talk to your wife about questions. I'll talk to my wife about questions.
Right.
Each of us make either a better attorney or a better judge. And as all typical things, I'm smart until I get home and I forgot to take out the garbage. Okay, so I never really saw it as a problem. In the beginning, people didn't understand until I think they realized that both of us gave a serious importance to the job, and I think people appreciated that. And then I think we were accepted, and I don't think anybody has a problem. No. And I think most of the time, quite frankly, I think especially in some vicinages, people were very happy when they got us as opposed to somebody else.
Okay, how about during the time that you were on the bench, what would you say, in your opinion, were some of the more significant changes in comp? Like, I'll leave that open to anything. Rule changes, how cases were being tried, how judges were approaching cases, anything that you think over the 21 years.
I'm going to go out of order. I'm going to go kind of by time.
Sure.
And then I'm going to go by what I think is trending. First, we had the Supreme Court case Kibble, which defined dependency claims. And one of I see it, people doing it. You have to liken it to family law. You have to get the other spouse to waive the dependency claim. You can't have the petitioner waive their own petition. It's done, and it doesn't make sense, and it's wrong. The second change was child support. There's a lengthy history to child support. Nobody needs to know that. You just need to know the following. There's a uniform state child support law, and if the person has a child support in multiple counties or out of state, you only have to pay one county. Court rules, Superior Court rules dictate, and the Uniform Child Support will dictate how that goes out. You don't have to think about it. Okay. Not your problem. The biggest problem we have is Medicare. That's not going away, and you just have to deal with it. Now, going from trends, there was a trend when I started that, and this is now 2020, when I first started, everything was tried to make compensable by the appellate court. I think as expenses, medical expenses increased, there's now a trend to have it tighter and make things less compensable. So that your parking lot cases and some of these things, the court, the appellate courts kind of try to tighten it up. There are cases that are all over the place when it comes to unreported cases. And sometimes you wonder who wrote this and did they have an understanding? And I'm not being disrespectful for the from the appellate court. It just goes you're going over 100 years of cases, and things shift. The statute changes. So, you know, that would be the trend that I'm seeing.
Yeah, to some extent, do you think the trends in, as you were talking about, tightening up some of the compensability issues, I saw that as well. I always thought that might have had something to do with the fact that it seemed like, especially I think when Governor Christie was in, I think that a lot of the Supreme Court, he was able to select a couple of justices to the Supreme Court. And what I saw was it seemed like they had, when things were going that far, they seemed to somewhat be reined in a little bit. Then the appellate division would sometimes affirm, and then you'd see a Supreme Court reverse.
Right.
Which I think happened on a few occasions with some of those parking lot, you know, what's the deviation type cases and those types of things that I thought had been getting expanded and then started to contract, I think, in that way. I think that was, in my opinion, that seemed to be what triggered that to some extent.
I would agree with you, and it's also so fact specific.
True.
What if I were to argue a case, I would try to use the LSAT type arguments. And this way, you try to handcuff the appellate decision. You say, well, if you're telling me I can't park here, therefore you're telling me I have to park somewhere else.
Right.
So are you giving me instructions to park in that location?
Right.
And you can, and there are different ways of doing that. There's also some cases where people have been found to be off-site. That's something which now is much tighter. The injury has to be on the control of the employer.
Mm-hmm.
Okay.
Yep. Absolutely. And that's all definitely, I think you're right. It's been scaled back in the last few years. With regard to cases themselves, what actual cases, either you heard or cases just in general, what do you think were the most impactful cases during your time on the bench?
Okay,
in your opinion?
I didn't want to go into war stories because that's boring and nobody wants to hear it. So
a summary.
I have basically two.
Okay.
All right. And the first one was Harrison. It was a hepatitis C death case for a nurse.
Okay.
The carrier didn't put time into the case. They didn't look at the case. They didn't question the compensability. They sent different attorneys to cover the conferences. They put out a small Section 20 offer. They didn't have any, the attorneys really couldn't articulate a alternative. Those are all bad moves. So when I say significant cases, I'm saying cases that I think you, as a carrier and as an attorney, you have to understand you can't, that's not the way to handle a bad death case. Eventually we had a trial, dependency was granted. There wasn't an appeal because there was, they had no place to go. They had no articulable defense. And I was a young attorney, a young judge, and I'm not going to shift fees. It's not something I do. The second case I had was a heart attack death case. Every time I had an issue, I would reread the statute, reread my notes, and take a look at the case law. You know, when you write a decision, you write the decision first, and then you read the briefs to see if you missed something. This way, you're not tainted. In this case, the carrier went out, got an expert from North Carolina, and did a very, very good job indicating that this heart attack was not related to work activity, which was the work activity was many hours prior to the heart attack. And again, that's when counsel adjusters need to know when they need to get high quality experts. Okay. Adjusters should understand that judges read everything and have a good understanding before the case starts. Not that their mind is made up, but what issues need to be addressed. There's nothing worse than reading a appellate remand because they're missing issues. So going in, they're going to, a judge should know, and he's going to have a checklist of what issues are out there, and sometimes they're missed.
Oh, sure, that's a big problem. With regard to advice, this is an interesting area. I thought that this would be something, now that you're looking at it from now outside now. What advice would you give to attorneys? And I guess a spin-off question of that is, what would be your biggest, I call it a pet peeve, but what would be your biggest issue you found with attorneys that appeared before you?
Okay, I tried to truncate this as much as possible. Okay.
Yeah,
all right.
we don't have all that much time.
Okay, and I get that. An attorney has to maintain his credibility at all times. If you oversell something, it's going to be remembered, and you lose your credibility once. And you have to put yourself into, if you were a judge, what would you think? Now, when a judge is hearing a case or conferencing a case, he's thinking about what the appellate division is going to say about him. So as an attorney, as an adjuster, you have to put yourself in a judge's position saying, what is the appellate court going to do? The second thing is, you really need to know your file, understand the issues are involved. Sometimes have a printout of the body part to show what's been injured. If it's a hand and it's an injury in the hand and it's a orthopedic, print it out, say, this is what I looked at, and this is what's going on. That can be very, very helpful. Also, be cordial. This is not Superior Court, so you don't be rude. You're going to see these people over and over again. If you're not ready, tell the judge. Parties should have agreed to have gross weekly wages and basic facts agreed upon before you go to a judge. If there's an issue, you say, we have an issue as to this. It's kind of annoying when you ask, okay, you're trying to evaluate the case. One of the most important things are what are gross weekly wages in your year, and you get you don't get an answer. We think it's this, we think it's that. Well, you should have brought that up before. What a judge doesn't like. Oh, let me go back one second. If there is a fact that's an issue, bifurcate the case as to that fact. Otherwise, you're wasting everybody's time and money. Wage reconstruction is a very, very hard thing to prove. What a judge doesn't like to hear is, I don't know, or what we refer to as IDKs. If you get something you really didn't know, then say, Judge, let me get everything I need to know. I'm going to call my client. I'll be back in a few minutes, so that the judge doesn't have to reload all this into his brain, and they'll appreciate that. Another annoyance is an attorney who doesn't really answer you or gives you a BS answer. It's almost more annoying than an IDK. Okay. I think really egregious is an attorney who attempts to reconference a case where the judge has already conferenced it, and given a suggestion, but is now not told that he's already reconferenced it. So that's always one of my questions is, have I conferenced this before? Because surprisingly, people will try to get you to do that. And if you do that to a judge, that judge is going to remember you forever. Okay.
All right. With regard to the claims handlers, because they're really the people who kind of prep us for going to trial, what advice would you have for people handling claims?
Well, there's a lot of people who say that, in superior court, adjusters and handlers have a lot more power than they do in workers' compensation. And I think that they have to put their minds into where they are and what they're doing. I think that adjusters or handlers need to keep an open mind and again maintain the theme that they have to trust the attorney who's sitting in chambers. The attorney knows the judge, knows his general dispositions. I suggest you place yourself as a judge and re-examine the file of your initial beliefs. Take a denial of a body part. Ask whether the another injury at the time was so bad it was masking that original injury, as opposed to saying we don't care. He didn't say it in the ER, so we're not going to deal with that. Which kind of brings up the problem of med motions. And you have to put yourself in the mindset of a judge. Does it help you to send a petitioner from a treater to a cutoff doctor to end treatment? Be the judge. If the judge is going to read the medical records, judge is going to have some idea what's going on. I suggest that you have the attorneys say, okay, before you file that motion, let's agree to a third-party evaluation, and this way try to avoid a trial and be exposed to 20% attorney's fees. Now, as far as third-party evaluations, there's two things you need to know. One, a judge is not going to be bound by that. Otherwise, you don't need judges. Two, the third-party evaluation, if you do go to trial, that's actually not, you can't cross-examine it. It's hearsay, so you would have to bring in that person.
Yep.
Again, trust your attorney, contact him, inquire from petitioners if we can send it to another doctor. Keep in mind that the doctor you want to send him to is in your network. You don't want to send him outside your network because then you're going to go and get reasonable customary bills. And it's MPCs for judges are just a nightmare. Chris knows how to avoid med motions and how to avoid an extra 20% fee from people who this is the practice of comp. You want to file as many med motions as you can because you want to get as much money as you can. Occasionally, and this is something I know which drives adjusters nuts, occasionally an attorney will come back and seek additional money than the authority has already been given. And you have to, I suggest, take a deep breath and say, trust your attorney, there's a valid reason. And one of the typical reasons is, Judge, I'm sorry, I really didn't discuss this, the extent of the injury with my client. I've now learned that he's changed jobs. He can't do it this. It was subsequent to me originally talking to him. You're going to get all types of those excuses. You reconference the case. You have to take his testimony, you take his testimony. And then you have to ask yourself the following question. Okay, now all this has happened. Be a judge, what do you think a likely trial outcome B. So it's going to happen occasionally. Don't get angry at it. Be flexible and say, there's a valid reason. I trust the boots on the ground. Your job is cost containment, and move a case. Now that you're dealing with people, it doesn't mean that getting the petitioner better is a bad thing. If you have to send them up to hospital special surgery, you're going to be paying less permanency. You may be avoiding a total case. They'll take Horizon Blue Cross Blue Shield rates. You're out of state. You try to, they don't take comp rates. Okay, try to go to Horizon Blue Cross Blue Cross rates. Try to get the person better. And I did want to segue into fraud. That's okay.
Yeah, absolutely.
All right. There's a lot of attorneys firms pushing for fraud. All right. And fraud goes both ways. If you read the website, you wouldn't guess an employer can be found committing a fraud. And this is where you have to be careful. Because if your allegation is foolproof, then you may give it a hesitant attempt. But again, remember, you lose your reputation once and you lose your credibility once. So you're putting that attorney and his boots in the chambers in a tough position. Once the word fraud is alleged or spoken, even in chambers, you have to have a trial. So, okay, have a trial. Just because somebody exaggerates a bit doesn't mean that that's fraud. Now, surveillance. Surveillance, I've had good surveillance and I've had useless surveillance. There were two cases we thought were total. We had surveillance and I found them to be a third of total. And I didn't get into any fraud issues. If you want to go into the fraud issues, you take a look at the civil and criminal jury instructions, and that'll give you an idea what to do. Also, don't ask for meaningless records that have nothing to do with the case, just to build up a file for discovery.
Yeah,
it's going on long.
Well,
everybody have a cup of coffee.
Nah, this is great. We're gonna wrap up here in the next minute or two. Yeah, I found my experience with surveillance is I always tell my adjusters it's a home run or a strikeout. I think you get good surveillance, it's a home run. A lot of surveillance is a strikeout, but it's sometimes worth a try to do it. You see what you get. You don't always have to disclose that you did as long as you're not going to use it at trial, you can get the surveillance and look at it yourself and see what you think and then decide where you want to go with it from there. So that is good. That's good advice with regard to that. I'm going to move forward a little bit on some of this here. So I just, with regard to,
I have assessing credibility.
Yeah, that was where I was going to go. I didn't know if we wanted to just.
Yeah, well, okay.
You want to just jump into that real quick?
Yeah.
Maybe just cover a couple.
Assessing credibility. Once again, what would you do if you were a judge, and how would you do it? Okay. I believe facts should flow in the easiest path, just like lightning. What did the petitioner first tell a treating doctor as to complaints? Were there things masked? Was there a realistic work or home life change commensurate with the injury? Most people don't give up a good paying job for temp, and most people don't try to build up a comp case. Do the complaints fit the pathology and ending treatment records? There are Superior Court long and short jury instructions as to credibility findings. That would be helpful for someone to read. And we talked about surveillance.
Yeah.
Okay.
I think we're getting close to the end here. I think really I was going to ask, yeah, I know you see a lot of doctors going in front of you. How do you feel with regard to a unusual type injury when you have a medical, potentially either a medical provider, or you want to try to look at a value? What do you?
That's something that wasn't on your list. I'm
Right.
going outside it.
Right.
And I think it's really important for people to understand this.
Okay.
There are so many injuries that aren't standard that come before you. We're going to take a hand injury, okay? And you go, okay, I have this injury. We're not doctors. We look up, we get all the information. People will Google it, and you have to ask, okay, with the complaints and what's in the doctor's report, is this case worse than an operated carpal tunnel, or is it about the same or better than a unoperated carpal tunnel? And that's how you try to triangulate on a value that's not standard.
Okay.
Okay. And let's see, go ahead.
Well, we're going to talk, I guess, a little bit about doctors that appear in front of you, medical experts, I guess, of any type, not necessarily just doctors. How do you assess them when you're seeing them in front of you and you're hearing them testify?
This is going to be really short. Everybody hears, most people be an attorney. I think most adjusters understand. So to keep it really short, I'm going to say medical experts can they articulate the mechanism of injury? Mm-hmm. Can they explain the pathology? And I'm going to be asking questions. Okay, and I can get into that later why. Logically explaining what the pathology causes these restrictions. Are they giving you straight answers? If I'm getting non-answers, then that's going to hurt the credibility. But you know, if you have a fracture and a doctor comes back and gives you a 0, yeah, really? Sometimes you just
Right.
You just have to look and use common sense. Okay.
I think we're up to. I called this your final thoughts with regard to.
Okay. It's final thoughts because
it's last thoughts.
They are called final thoughts. Okay. For the adjusters, give the attorneys the information they need. Do not have unreasonable expectations. The other is don't underestimate your adversary. Be flexible. You are there for cost containment, but remember you're dealing with people who need help. Getting better sometimes means less permanency. The playing field can change rapidly. There can be additional facts. There can be an additional record. Be flexible, adjust reserves as needed. Keep to an attorney and stick with that attorney and follow his lead. Of course, you can ask him questions. Remember the case where the hepatitis C, I kept getting different attorneys. Nobody took the case seriously. And that was just a total waste of everyone's time. The attorney is in the courtroom, knows the players, has a good idea what the potential exposure is. I don't suggest testing judges. They can be fair, and they can go and have trials. If an attorney asks you to go to court one day to see the debacle in chambers that this case is causing, okay, the attorney will say, "Judge, can I bring in my adjuster?" The judge, I've never heard of a judge say no, because the adjuster knows questions and will be helpful. And then the adjuster will then see a judge has actually physically read the reports. has actually physically looked at the treatment records and has asked questions. And then the adjuster gets the ideas, oh, they're not just picking a number between two numbers or making up a number. They've actually put thought into this and they've asked questions. So a lot, and that's something which, you know, as a judge, you wonder, what do they think we're doing? So that's what I would do, is be flexible, trust your attorneys, and remember, you lose your credibility only once. Okay.
Fantastic.
Okay.
Judge Barrett, this has been really more than insightful. You went above and beyond with regard to the questioning and your insights, and I think this is great information. So,
okay, it's been a pleasure. Good luck,
everyone. Thanks very much. This is going to end the first podcast, and we'll keep online. We will be doing updates probably every other month or so with regard to new cases and issues as they come up in the comp division. So, take care, everyone.
Take care. Thank you.